Hello and welcome back to the another episode of Indian Polity Lectures. Well, it is lecture number 27 and the date is 14th July 2025. Well, in this video we are going to discuss the Indian judiciary. Before we'll start our discussion, I would like to give the brief introduction about this initiative which we had started from 2nd June 2025, so that if you are new to our channel you will get more connected with us. Basically from 2nd June we started an initiative here by the name Target IAS 2026. Under this initiative, every day we upload two videos. One in the morning session where we discuss your current affairs. We take up the most important articles and we relate them for you with respect to your prelims preparation as well as your mains preparation. And in the evening session, we upload another video where we discuss your static syllabus. And here we have started with Indian polity. As you can see, it is the 27th lecture. Now only 3 lectures are left after this lecture. Then we will complete the full syllabus of Indian polity. Here we had promised you that by the month of January 2026, we will try our best to complete your full syllabus. In it, we will cover your syllabus related to your prelims as well as your mains. But here is an exception that we will not cover your optional subjects. And at the same time, as we are delivering these lectures, we are preparing your notes. These notes are very much different from the conventional books which you read, because in here what we do, after every topic which we discuss in the notes, we bring up the most possible prelims question which can be asked from that topic, or the possible mains question if the topic is related to your mains preparation, so that it will give the idea when you are reading these notes that which are the topics which are important for your exam and how can be questions asked through these topics. So this is the idea behind these notes. If you want to get the service of these notes, you just have to email us, and then you would be told to pay 200 rupees per subject, so that you will get the access to these notes. It is up to you. It is totally optional. If you want, then you can mail us. Other things what we do here, the static syllabus which we cover here, it is totally free, as you can see, totally available on our YouTube channel. And this is the same coaching which you get from other coaching institutes. If you want to be the part of it, please do subscribe the channel, do share it with your friends, and also do write in the comments what else should we bring for you guys. Now, without any delay, let's start our discussion from the topic which we have to discuss today. As you can see here, the topic is Indian judiciary. So let us see what is Indian judiciary, how it is important, what are the functions, what are the offices under Indian judiciary, what does the constitution say, and what are extra constitutional offices which deal with the judiciary. Let's try to discuss them. When we started our discussion, in our first lecture we discussed that one of the feature of our constitution is the separation of powers. Separation of powers. This separation of powers is between what organs? It is between the legislature, between the executive, and between the judiciary. What they do, they check and balance each other. Separation of powers is not only giving them separate powers, but they have to check and balance each other. That's what they do. And with respect to legislature, we discussed, we put more focus on this central legislature, union legislature, because that is what is relevant for your preparation, and also what applies to the center, same applies to the state. Where the difference is, where we discussed them. Then we also discussed the executive, mostly with respect to the union and also with respect to the state where it was necessary. Rest it is same. In union we discussed the governor separately. And now today we are going to discuss the judiciary. About the Indian judiciary, there is hierarchy in it. What are the offices in the Indian judiciary? If we look at the hierarchy, what does the constitution say? According to the constitution, at the top there would be the Supreme Court. Below Supreme Court there would be High Court. And below High Court there would be district courts. It is what the constitution says. These courts would be there. And what are the extra constitutional offices which deal with the judiciary? We have we have Gram Nayalayas. We have Gram Nayalayas, which are extra constitutional, which were brought by an by an executive, by an legislature, which were brought by an law, which are statutory in nature, which are statutory entities, which are statutory in nature. So this is what the Indian judiciary is about. Now let's see what is the importance of the judiciary, what is the primary role of the judiciary. The first question which everybody should ask themselves, what is the primary role of judiciary? Primary role of judiciary. First, the basic thing, which if you will ask a layman, if you will ask a fifth class student, why do you think judiciary is there? The first thing what he will highlight is that to punish the criminals. Punish the criminals. So what is the importance of punishing the criminals? Suppose there is a criminal, he committed the crime. Now, why we need to punish them? The reason for that is, first, to deter others from doing such crime. If you are going to punish anybody who, for example, there is a person who has committed a murder, and if you will leave that person alone, there is no punishment for them, then what will it lead to? It will lead to the chaos in the society. Everybody will get they will get inspired by them, and they will start doing the same, and there would be no law and order in the society. So this is the first thing, to deter the people in our country not to do this act. And also, if he has done anything harm, if he has done anything wrong, that wrong needs to be punished. He has committed any crime, then there is a law which prescribes the punishment for that, and this punishment should be given to this person, so that it will not happen in the future, and there would be the law and order. There would be the people, there would be law and order in the society, and the people will live in peace. This is the primary function of the judiciary, to punish the criminals. Second, what is it? Second function. What is the second function? What is the second role of the judiciary? To ensure constitutionalism. The second role of the judiciary is to ensure constitutionalism. So what is this constitutionalism? If you remember our first lecture, we discussed about it, that constitutionalism, it is in a way, it restricts it limits the powers of the government. For example, where the government is exceeding its constitutional limits, there the judiciary will come in, and it will limit the powers of the government. It will limit the powers of the executive. So the second primary role of the judiciary is to ensure that there is constitutionalism. Then the third, we have the federal structure. We have at the top, we have center, at the bottom we have states, at the mid we have states, and according to some, we have the local governments too, which they consider it is a it is the part of the federal structure. But according to me, that is not the true. But the reality, the point which I am trying to highlight here is that we have federal structure, we have center, and we have states. There might be conflicts between the center and states. We saw that what is the relationship between center and states, what are the executive relations, what are the legislative relations. So there might be conflict between the center and state. Who will solve these conflicts? It would be solved through the judiciary. There would be the conflict between state and state. Who is going to deal with it? Who is going to arbitrate it? It would be the judiciary. So judiciary will solve these issues. Then the fourth primary role of the judiciary is the judicial review. It is the judicial review. If you look at the constitution itself does not talk about the judicial review, but it is the basic structure of the Indian constitution. It is what we infer from the constitution, that the judicial review is the part of the basic structure of the constitution, so that constitutional laws are followed. They are followed in letter and spirit. So these are the basic functions of the judiciary. And now we understood that what are the primary functions of the judiciary. We understood that what is the hierarchy in the judiciary. At the top there is Supreme Court, then there is High Court, then there are district courts, and then we have Gram Nayaliyas, which were introduced in 2009. Now let's start discussing what is Supreme Court. Let's see what does the constitution say about the Supreme Court. What are the powers given to Supreme Court? What is the jurisdiction of the Supreme Court? Let's try to understand these important topics one by one. Let's try to find it out. So first, let me rub it and see what are the articles which deal with the judiciary. For that, to understand it, we have to start with Article 124, Clause 1. Let's see what does it say. Article 124, Clause 1. Let's see what does it say. It says, there shall be the Supreme Court of India consisting of Chief Justice of India and not more than 7 judges. But originally, the Constitution says, originally Constitution says under Article 124 Clause 1, it says there shall be the Supreme Court, there shall be the Supreme Court of India, there shall be the Supreme Court of India consisting of Chief Justice of India and not more than 7 judges. So what does the Constitution originally says? There shall be the Supreme Court of India consisting of Chief Justice of India and not more than other 7 judges. What are these other 7 judges? They may be called anything. They are often called as brother judges or other judges. Whatever you want to name them, you can name them in your own way. So this is what the Constitution says originally. It says under Article 124. So originally, what does the Constitution say? That there shall be the Supreme Court of India consisting of Chief Justice of India and not more than 7 judges. So if we look at the Constitution, it in a way restricts by this article itself. It restricts what it does. It restricts the number of judges. But what is the number of judges which we have presently? What does the how many judges we have in the Supreme Court? What is the number of judges we have presently in the Supreme Court? If we look at that, currently there is CGI plus 33 other judges. So how did, even though Constitution was there, Constitution was clearly saying that not more than 7 judges, how did we reach to this number? For that, we have to look further. What does the Constitution say? Further, the Constitution says that Parliament can increase the number of judges. Parliament can increase this number of judges, and it should by an law, and it should not be deemed as the Constitutional Amendment Act. So the Constitution is very much clear that if today, when the Constitution was enacted, at that time, what was the structure of the Supreme Court? The structure was the number of judges were 7 with CJI plus CJI. But the Constitution was very much clear. If tomorrow you need more judges, tomorrow if the burden of cases are huge in the Supreme Court, then you might need more judges, and you can do that. But it is the Parliament which will make law about that, and this law which the Parliament will make will not be deemed as the Constitutional Amendment Act. So this is why we have today the 33 judges plus the Chief Justice of India. This is what the Constitution says under Article 124 Clause 1. So after this, you need to know, when there are judges. Now about the judges, we need to know what is the qualification of the judges. What does the Constitution say about the qualification of judges? How the judges are, how the judges occupy their seats in the Supreme Court. Let's try to understand that. What are the various qualifications of the judges of the Supreme Court as well as High Court, because it is almost similar. That's why we are adding both here. So the qualification is, first and most important, he should be the citizen of India. He should be the citizen of India. So in what way he should be the citizen? Is it by he was born in India? In any way, whether he has got his citizenship through the naturalization, registration, whatever way he has got his citizenship, he should be the citizen of India. That is the only criteria. In what way, that doesn't matter. So first criteria, he should be the citizen of India. Second criteria, which is required for a person to be the judge of the Supreme Court, is he should have the 5 years experience of judge of one or more than 1 high courts. What does the second criteria say? He should have the experience as in judge of high court, as in judge of one or more high courts. He should have an 5 years experience of a judge of he should have a 5 years experience being as a judge of one or more high courts. So this is the second qualification for him: 5 years experience as a judge of one or more high courts. Then if there is a person, he does not have these qualifications, he was not a judge for a high court for 5 years, or whatever the qualification we discussed here, then is there any other criteria that a person can be the judge of the Supreme Court? Yes, he can become the judge of the Supreme Court if he has experience of 10 years, if he has a 10 years experience he has a 10 years experience as an advocate of a high court or two or more such courts. If he has an experience, if he has a 10 years experience as an advocate of a high court or two or more such courts. If he has an, if he, if for example the first criteria to be the Supreme Court judge is citizen, let's leave it aside, everybody is citizen here. Now the second criteria, he should have the experience, he should have the 5 years experience as the judge of the one or more high courts. This is the first criteria. If it is not fulfilled by the person, then what is the other criteria? The other criteria is that he should have the 10 years experience as an advocate of a high court or two or more such courts. So this is the second criteria. Now let's suppose there is a person who does not have these two criteria. Is there any other criteria? Yes, there is other criteria. What is that? He should be, in the opinion of the president, a distinguished jurist. What is the third criteria? He should be, in an opinion of the president, a distinguished jurist. If these criteria are to be fulfilled, either one of these criteria are to be fulfilled to be the Supreme Court judge. Suppose there is a person, he wants to be the Supreme Court judge. What should be his criteria? Criteria number one, he should have the experience, he should have been the judge, he should have the 5 years experience as in judge of any high court or more such high courts. He can be the Supreme Court judge. If he is not, if he was not a judge of any high court, then the another criteria comes in. He should have the experience of 10 years as an advocate of a high court or two or more such courts. If this qualification is not fulfilled by any person, then there is a third qualification, and that is he should be he should, in the opinion of the president, be a distinguished jurist. So these are the qualifications for a person to be the judge of the Supreme Court. Now let's see, we understood what are the criteria of a person to be the judge of the Supreme Court. Now let's see what are the criteria of a person to be the judge of the High Court. The criteria, let me rub it first, then we will write the criteria of a person to be the judge of the High Court. Let me write it, let me rub it first. What are the qualifications of a person to be the judge of an high court? For that, he should be the advocate in one or more high courts for 10 years. This is the first qualification which a person should fulfill to be the judge of an high court. And second, he should be the judicial officer for 10 years. These are the only two criteria for high court. Let's see what are the criteria. First one, advocate in one or more high courts for 10 years. Advocate in one or more high courts for 10 years. Then the second criteria is judicial officer for 10 years. Judicial officer for 10 years. Can he be the district judge for 10 years? Yes, if there is a person who is a district judge for 10 years, he can be promoted to be the judge of the high court. So he is a judicial officer for 10 years. Is there any third condition like we saw in the Supreme Court? There is a third condition that in the opinion of the president, a distinguished jurist? No. For the high court, there is no such third condition. For the high court, there are only three conditions. The first, citizen. The second, advocate in one or more high courts for 10 years. Third, judicial officer for 10 years. So this is what this is the qualification of the person to be the judge of the High Court and the Supreme Court. I hope you had got this very well. There is no need, there is no scope of any confusion. The only difference is that the major difference in the High Court and Supreme Court is that in the Supreme Court there is the qualification which prescribes to the opinion of the president. In the High Court there is no such qualification. Now let's see how they are appointed. Now our discussion will actually start. How they are appointed. Appointment of judges. We saw that they are the qualification. Now let's see how they would be appointed. Let's see what does the Constitution say. Under Article 124 Clause 2, Constitution was very much clear in few things. Let's see what are these. The Constitution says every judge of Supreme Court shall be appointed by President. First thing, every judge of Supreme Court shall be appointed by the president. So this is the first condition. What does the constitution say? Article 124, every judge of the Supreme Court shall be appointed by the president after the consultation with such of the judges of the SC and Supreme Court and the High Court in one state as the president may deem necessary for the purpose. Second, consultation. Second important thing is consultation. And if it is with respect to the Supreme Court, then it would be then it would be any judge from the Supreme Court, any judge from Supreme Court, or any judge from the High Court, and the High Court judge whom he has to, for example, anybody who would be appointed as a Supreme Court judge, by the qualification we saw that he would be promoted from the High Court. So definitely the High Court judge would also be consulted, and it is up to the president to whom he may consult. And by convention it was the, for other judges than CJI, it would be the CJI. So what would be the convention here? Convention, I will write here. The convention would be provided in the case of a judge other than CJI, the CJI shall always be consulted. So for if the case is with respect to other judges, then the Chief Justice of India will always be consulted. So here what does the article say? Article here clearly lays down the grounds how the judge would be appointed. For example, it is the president who is going to appoint the judge, and he will, for the appointment, president may not have the knowledge how the judiciary will work. So for that he will need what? He will need guidance. Then for that he will consult. He will consult the judges of the Supreme Court. He will consult the judges of the High Court. And if it is the matter of any other judge than the Chief Justice of India, then he will consult the Chief Justice of India too. And with respect to the High Court judges, president can also consult the governor of that state. With respect to High Court judges, president can also consult the governor of that state. So it was originally what does the constitution said about it. But with respect to this, there were various questions were raised. For example, with respect to the, what were the conventions followed. For example, for the consultation, if they have to, for example, they have to Chief Justice of India, they have to appoint the Chief Justice of India. What would have been followed? Majorly it would be the, what is the experience of the judge that was followed. Who is the most experienced judge? Who he will act as the Chief Justice of India. It was the convention. But at some places this convention was not fully followed. This convention, the convention about the experience was not fully followed. So this case, the first time this case went to the Supreme Court, and it was heard in the case went to the Supreme Court, and it was heard under SP Gupta versus Union of India in 1981. So this, with respect to this, about first the question was with respect to the consultation. Is this consultation binding on the consultation of the judge is binding on the president? It was very much understood it is just a consultation. It is not binding on the president. Then the second thing, which was in appointment, that for the appointment of the Chief Justice of India or the judge, the experience was the prime factor in that. But in most of the cases we saw that the experience was neglected. For example, during emergency, a judge was to be appointed as a judge, but his experience was neglected. Similarly, other cases. So this this criteria of experience was not fully followed. Because of that, there were many conflicts. Many judges who were to be appointed as the Chief Justice of India, by the how it was followed. Then they were the other judges who had least experience, they were chosen over them. So because of that, they resigned. Many judges resigned in such scenarios. For example, we have the case of Justice N. Roy. He was he was superseded by 3 judges, but he was given the he was appointed as the Chief Justice of India rather than those 3 other judges. So what happened to those 3 other judges? They resigned because they did not like it, because the experience, which was the primary criteria, which was followed by the convention, it was not followed in this case when they were appointed as the Chief Justice of India. Then further, in the emergency also, there was a judge there was a judge who was superseded by many, who was superseded by other judges, but he was made the Chief Justice of India other than other judges. So for example, we have Justice H.R. Khanna. Then during the emergency in 1975, he was the primary role. He was the person who was to be appointed as the Chief Justice of India, but he was denied his opportunity and he was replaced. Yeah, and the opportunity was given to Justice Beg, who has lesser experience than the Justice H.R. Verma. So because of this, there were huge conflicts going on. Whether this consultation, the conflicts were with respect to the president, whether this consultation is binding on the Chief Justice of India or not, whether the consultation is binding on the president or not, what the consultation Chief Justice of India gives, is that binding on the president or not. So whether the transfer of judges without their opinion, without their interests, can the president transfer the judges without the opinion of the High Court judges? So these questions were asked: can it be done or not? Is it in line with the Constitution or not? So with respect to this, the case went to the Supreme Court, as it is commonly known as the first judge's case, or we can say SP Gupta versus Union of India. Now let's have a look at this case. Let's see what were the questions asked and what did the judiciary said about it. The case which went to the Supreme Court, SP Gupta versus Union of India in 1981. So it is also known as the first judge's case. What were the questions asked in this case? Let's have a look at what were the questions. The first question which was asked: does the consultation mean concurrence? Does the consultation under Article 124 Clause 2 mean concurrence? Second question which was asked: can judges be transferred? Can High Court judges be transferred against their will? Can High Court judges be transferred against their will? So these were the questions which were asked to the Supreme Court at that time. Supreme Court said, look at the Constitution, look at the English dictionary. Does consultation mean concurrence? It is very much clear. Consultation means consultation. It can be the president will consult and he may accept it or not. So consultation does not mean concurrence. And the second thing, look at the Constitution. It says that it is the president who is going to appoint the judges. So it is up to the president. They can transfer the judges without their their will. So it can be done easily. But the things did not end here. This case again went to the Supreme Court by the other name, which is Scoro 1993. The case went to the Supreme Court again by the name Scora 1993, which is also named as the second judge's case, and it is first time when the collegium system came into existence, and it fully contradicted with the SP Gupta versus Union of India. So let's see what were the judgments made under this second judge's case. Let's have a look at it. What were the judgments made under second judge's case? The first thing, the question about the concurrence, when it was asked to the judges, what did they say? Appointment of judges. So they said that in appointing the judges, it is the participatory in nature. It is an participatory exercise between the executive and the judiciary. Second, the aim is to hunt for the best talent, and the third is integrative in nature, to integrate the executive and the judiciary. So here in the second judge's case, it was the first time the Supreme Court said that the consultation means concurrence. What was the major aim of it? The major aim of this judgment was that, what were the issues coming before? The issues were the Supreme Court, the president will consult the Supreme Court judge to whom he may seem fit with respect to the appointment. So with respect to that, what was the criteria followed? The criteria which was followed for the appointment who is the most experienced. But in many cases that criteria was not followed, for example during emergency. So with this regard, the matter went to the court, and the courts in the SP Gupta versus Union of India said that consultation does not mean concurrence. For example, even if the collegium will recommend any name, it is up to the president to whether choose him or not. So it does not mean they are recommending that he has to accept it now. And the second thing, he can transfer whoever he wants without the opinion of the judges. So this was established in the first judge's case. In the second judge's case, the Supreme Court changed its verdict. In it, it said that, what is the aim of this consultation? Even though the constitution says it is consultation, but what is the aim of this consultation? The aim is that it is a participatory exercise between the executive and the legislature. They would participate in appointing the judges. The second aim is to hunt for the best talent, and how we can hunt for the best talent, who has the best experience in it. Then the third, to integrate the judiciary and executive. And finally the Supreme Court said that the consultation does mean concurrence, that if the president is consulting with respect to the appointment, and the judges will recommend any name, that is concurrent on the president. So it is the consultation does mean the concurrence. So it was established. And second, with respect to the Chief Justice of India, they said that Chief Justice of India, it is not a person, it is an institute. So with respect to this, they said that they introduced the collegium with whom the president will consult. It would be the Chief Justice of India plus 2 senior most judges, plus 2 senior judges of Supreme Court. For example, they have to appoint a Supreme Court judge. For that, they will consult now the Chief Justice of India plus 2 senior judges of the Supreme Court. And this name which they will give, that would be binding on the president. This name will be binding on the president, at least on the paper. That name will be binding on the president. This consultants means concurrence. Then the third, then when it was changed, so the Parliament of India, the government of India recommended president to send this case back to the Supreme Court, so that they would revisit the appointment of judges case, and this became the third judges case. So this became the third judges case. Now let's try to find out what were the few important aspects of the third judges case, what we follow right now. This second judges case, the changes which were made in here, for example, with respect to the collegium, with respect to the consultants means the concurrence. It was, the Parliament of India, it recommended president to send it back to the Supreme Court, so that they will revisit this case. So with respect to this case, it became the appointment of judges, revisit appointment of judges 1998, and it is called as the third judges case. Let me rub it, and we will discuss that what were the provisions of this third judges case, what we follow right now, what were the changes made to the second judges case, and what we follow right now. The revisit appointment of judges 1998, also called the third judges case, So at that time, who was the Chief Justice of India? He was Justice Verma. So let's see what were the important provisions which were established. The Supreme Court gave the same logic, integration. Supreme Court gave the logic of consultation, the participatory exercise. So definitely the consultation means the concurrence. This is what it was established. Then the second thing which was established, that the outgoing CGI, Chief Justice of India, will nominate his successor. And how it would be achieved, how this would be achieved. This Chief Judge, the outgoing Chief Justice of India, for example, we have Justice Khanna right now. He is the Chief Justice of India. When he would be retiring, he would appoint his successor, and his successor who is fit to hold the office. Successor who is fit to hold the office. About this fit to hold the office, who will decide it? Yet there has no such case on which this question was asked. So we don't know who will decide it fit to hold the office. Is it the president, or the Chief Justice of India who will decide it. We don't know about it. Then the third, for example, you have to appoint a Supreme Court judge. For that, you have to consult the Chief Justice of India plus 4 senior most judges. So now the collegium expanded. Earlier it used to be, in the second judge's case, it used to be Chief Justice of India plus 2 senior most judges. Now in the third judge's case, it is the Chief Justice of India plus 4 senior most judges. And any name, if there, for example, now there are 4 judges, how they will appoint, how they will reach to any name. For example, there are these 4 judges, they recommend some name, and the Chief Justice of India does not accept that name, then such recommendation cannot be given to the president. So Chief Justice of India has to accept that name. And with respect to the High Court judge, there is also a collegium, which is Chief Justice of High Court plus 2 senior most judges, This is a collegium for the Chief Justice of High Court. And also with respect to the transfer of the High Court judges, for that you need to consult whom. If you want to transfer the High Court judges, you need to consult the Chief Justice of India. You need to consult 4 senior judges, and also you need to consult 2 Chief Justice of High Courts. Why these 2 Chief Justices of High Court? Because one would be from the state from where he is being transferred. The second one would be the state to which it is being transferred. One would be from the High Court of any particular state from where this judge is being transferred, and the second one would be the High Court to which he is being transferred. That's why there is these 2 Chief Justices of those high courts are consulted. So this is the criteria with respect to the transfer of judges. So this is what we follow right now. This is what we had reached right now. So the collegium was established. Collegium was established. It was expanded to the 4 Chief Justice of India plus 4 senior most judges, and with respect to the high courts, Chief Justice of High Court plus 2 senior most judges. And what was the aim of the vacancies? What was the aim of this collegium system? And it was asked to the judiciary, why did you went for the collegium system? Earlier we had the good system. It lasted for many years. It lasted for almost 30 years. It lasted 40 years. What was the necessity of this changing? The Supreme Court said that, look at the president is appointing them, and president does not have this power on its own. He's following his government. What does his government will say, he will follow that. And if there are cases which are against the government, why would government want those cases to be solved in a very little span of time? So for that, what they would do, they would hesitate to appoint. They would leave many vacancies there. So to overcome these vacancies, to appoint the judges at these vacancies, we need to bring in the collegium system. We need to have this independence so that we will fill these vacancies, and that's why the collegium system is needed. And also, if the appointment is dependent on whom? If the appointment is dependent on the president, it is indirectly dependent on the government of India, on the political party who is governing that time. So definitely the independence of judiciary will be under threat, and the independence of judiciary is one of the basic structure of the Indian Constitution. So these were the statements given why why the collegium system is justified. So with respect to this, about the collegium system, it is not, again I will reiterate here that collegium system in itself is not mentioned anywhere in the Constitution, and why it was brought in majorly because to overcome the vacancies, and also to ensure the independence of the judiciary. Now let's have a look at the independence of the judiciary. What does the Constitution say? About the appointment of the judges, I think everything is clear. We first discussed the qualification, what are the qualifications, then we saw how they are appointed. For that, we saw that it is the president who will consult. Earlier it used to be he will consult any judge of the Supreme Court and High Court of his interest, and then that judge would be appointed. But then there were questions, what would be the criteria followed? Usually the experience was the criteria which was followed by the convention. But at many instances, we saw that experience was neglected in many cases. So with respect to this, the case went to the Supreme Court, and finally the Supreme Court in the first judge's case said the 2 questions were asked, whether this consultance is concurrence. The Supreme Court said no, It is the dictionary meaning. The second question was asked, can you transfer the judges without their opinion? The Supreme Court said 100% you can transfer it. Then this case went again into this to the Supreme Court under the second judge's case, and in this second judge's case, many things changed. First thing, it was established that concurrence, the consultation is concurrence. It does mean concurrence. Second thing, the collegium system was established. It is the Chief Justice of India and plus 2 other judges, and then also other things were also established. Then the case again went for the revisiting. Parliament recommended president to send this judgment appointment of judges again. Then we have the third judge's case, under which we established the collegium system with 4 judges for the states as well. We established the transfer of judges, how they can be transferred. For that you have to consult the Chief Justice of India, 4 senior judges, 2 Chief Justices of High Courts, and also we saw that Chief Justice of India, it is his statement with respect to the appointment of judges, it is very much the basic structure. It is very much the part of the basic structure with respect to the appointment of the judges. It is primacy of the Chief Justice of India in judicial appointment is the basic structure. We understood that too. So with this, now let us see what was the need of it to ensure that the judiciary is independent. It will work independently. If there are cases against the government executive, it will work independently. That was the need, and also the vacancies was the need of it. Now with this, let's move our topic towards the another concept about the independence of the judiciary. In here we will discuss what does the constitution say about the independence of judiciary, and what does the experts say about the independence of judiciary. Does it mean that only the executive and legislature cannot participate in the judiciary, or does it have the wider meaning? Let's try to understand that. Now the topic is independence of judiciary. Very interesting topic. So with respect to independence of the judiciary, you have to understand that, before we will understand independence of judiciary, we will try to understand the NJAC. NJAC was proposed by Mani. It was proposed by Atal Bihari Vajpayee too. And finally in 2014, by the 99th Constitutional Amendment Act, the NJAC was brought in. NJAC was brought in, and it replaced what? It replaced the collegium system. So what was the structure of the NJAC? What was the duty of the NJAC? It will deal with the appointment, transfers of the Supreme Court and High Court judges. Its primary function was that. And what was the structure of it? It will consist of Chief Justice of India. It will consist of 2 senior judges, so 3 members from the judiciary. It will consist of Union Law Minister, and it will consist of the 2 eminent persons. And who will appoint these 2 eminent persons? For them, they would be appointed by a committee, 3-member committee, which will consist of PM, which will consist of Chief Justice of India, which will consist of leader of opposition. So these are the members of the NJAC, and they will decide over the appointment and over the transfers of the judges. But this was not liked by the Supreme Court. Why? They felt that the executive is trying to intervene in the judiciary, and the judiciary by its verdict made it unconstitutional. The judiciary said that, the Supreme Court said that NJAC is unconstitutional. Why it is unconstitutional? Because the executive is playing part in it, in the appointment of the judges, and it was very much evident. For example, for any person to be the judge, if 2 or more members vote against that, then he cannot be the judge. If 2 or more, for example, these 2 eminent members and the Union Law Minister will vote against that person, then he cannot be the judge. So under this, when this went to the Supreme Court, the Supreme Court established that the concurrence of the primacy of the Chief Justice of India in judicial appointment is basic structure. So this amendment was made unconstitutional. So with respect to this, we understood the primary aim of the judiciary in the appointments is to secure the independence from the legislature and the executive. Primary aim of the judiciary is to secure independence from the legislature so that they can appoint themselves. And also the second aim was to fulfill the vacancies. But has the collegium system, is collegium system, has it been successful in fulfilling the vacancies? If we look at the data which is present to us today, approximately 45% of the 45% of the high court judges are vacant. So look at it. Even though they claimed that by the collegium system we will fulfill these vacancies, but 45% of the high court judges are still vacant. And if we look at the participation of women in judiciary, till now we don't have a single chief justice of India who is woman till date. And also if we look their participation, only something 13%, their participation in the judiciary is almost 13% only. In the higher courts 13% is their participation. So definitely their participation is very low, and definitely collegium system has not solved it yet. And also, what is the another concern with respect to collegium system? Even though they recommend who is going to be the judge, what are the criteria on which they recommend? What is the transparency with respect to that? What is the accountability with respect to that? That is not very much clear. There is lack of transparency and accountability. Lack of transparency and accountability with respect to the names suggested by the collegium system. And also with respect to this, a question was asked in Sore's India transfer. They challenged collegium system in 2010, and they asked two questions to the Supreme Court. For example, when the Supreme Court brought in the collegium system, the first question they asked to the Supreme Court, is it to be considered? You had amended article 124 clause 2, where it was very much evident in the primary constitution, where it is very much evident in the constitution that the president has to consult the senior most judge of his choice, and you had brought in the collegium system. Does it mean that you had amended the constitution? The first question. Then the second question was asked to them, if it is the amendment of the constitution, then what is the question? Can a constitution be amended by the judicial verdict? Then the second question was, can a constitution be amended by the judicial verdict? You know what the Supreme Court answered to it? The Supreme Court did not answer to these questions till now, and they also banned this organization to fill other PLIs. So this is till now what we had understood through the collegium system, how NJAC tried to replace it, but it was stopped by the judiciary, and the major aim was that they felt that it is the executive who are trying to interfere in the judiciary. Because of this, the independence of the judiciary can get violated, which is the basic structure, and also the concurrence of the primacy of the Chief Justice of India is the basic structure of the Indian Constitution. Now let's move to the topic, which is the independence of the judiciary. What does the Constitution say? How does Constitution fulfills this independence of judiciary? Even though NJAC is not there, or even though NJAC was there, but still this independence of judiciary would have been there. I don't know why the courts went against it. Maybe it was in their own interests. They know better. But let's see how the Constitution protects the independence of the judiciary. About independence of judiciary, you had, what is this? What does it mean? It means that judiciary should function independent of other organs. For example, recently we saw that the electoral bonds case was in the court, and if, for example, if Narendra Modi, he would have called the Justice Chandrachud that please give this verdict in my favor, then if the Justice Chandrachud would have given the verdict in his favor, does it mean that judiciary is independent? No, it does not mean. So this independence of judiciary means that it is independent of the executive, it is independent of the legislature. And also the Justice Chandrachud further said that it is independent of the social, and it is independent of social media biases too, social media pressure too. It is independent of the social pressure and as well as the media pressure too. And also it is independent of the inherent bias, inherent bias. What is this inherent bias? For example, you are a person and your affiliation towards any religion, you have affiliation towards any religion. For example, you are a Hindu and you have affiliation towards Hindu. Now there is a case where a person is Hindu and the another person belongs to any other religion. Now what is your inherent bias? It says that you should, you should favor the Hindu person. But for the independence of judiciary, you should go beyond your inherent bias. You should favor what is right, you should favor who is guilty, you should, you should favor the you should favor the constitution. There, what does the constitution say? You should favor the laws. Who is the guilty, you should not favor that person. You should favor what does the laws say, and you should be in line with that rather than what your inherent bias is. So if you are beyond this inherent bias, if you are beyond this if you are beyond this pressure from the media and the social media, and you are beyond from the pressure from the executive and legislature, then only we can call the call that the judiciary is that the judiciary which we are enjoying is the independent judiciary. So this is what the independence of the judiciary means. Now let's see what does the constitution, how does the constitution deal with the independence of the judiciary? How does the constitution deal with it? For this, when we discussed the governor, post of the governor, we saw that the post of the governor, there is one drawback. What is that? He is on the mercy of the president, on the mercy of the president. His appointment is on the mercy of the president. His tenure is on the mercy of the president. So because of this pressure, the president is in a way, he will accept what his government will say. So because of this, the governor has to follow what does the president say, and eventually what does the central government says. So because of this dependence on the pleasure of the president, the post of the governor is not independent. There are allegations against his post. So if it would have been same in the judiciary, then there would have been allegations against the judiciary. But constitution was the creators of the constitution were very much aware of it. So for that, they had they had given the appointment. They had, once you are appointed as a judge, you can hold office till certain age. They had given the age limit. What is for the Supreme Court judge, for him it is 65 years, and for the High Court judge it is 62 years. So once you are appointed as a judge, you cannot be removed. You cannot be removed by any simple order. For the removal, you need to the resolution should be passed by the parliament. That we will discuss in few minutes. So this appoint this how you can hold the office up till certain age. It gives you this freedom, it gives you the independence from executive, it gives you the independence from the legislature, it gives you the independence from anybody. Because of this, once you are appointed as a judge, you cannot be removed easily. Second, the second issue which can affect your independence is the salary. For example, if your salary is decided by the parliament, if parliament is going to decide and they are going to lower it, they are going to increase it, then definitely you would be very much favoring them. But here, with respect to the salary, your salary would be charged from the Consolidated Fund of India, charged from the Consolidated Fund of India, so that they cannot vote. They can discuss over it, but they cannot vote over it. And also about the pensions, it will also be charged from the Consolidated Fund of India. And with respect to your conduct, for example, you are a judge, your conduct cannot be discussed in any parliamentary meeting. Your conduct cannot be discussed. Only if there is a resolution to remove it, then it can be discussed. But naturally, it cannot be discussed in normal circumstances. Your conduct cannot be discussed. And also we discussed about the contempt of court. We discussed it in a very detail, how it is civil contempt, how it is criminal contempt. We had discussed it. The Supreme Court, the courts, they have the contempt of the court. If anybody violates them, they can be booked. They can book that person under the contempt of the court. And also, if they are to be removed, they are removed on the recommendations of the parliament. Removed on the recommendations of the parliament by the 2/3 majority present and voting. So which is this special majority favor 2? To know what is the special majority favor 2, I would recommend you to go to my third lecture. You will find it there. So please do follow my all lectures, because in here I had I had covered everything what is important for your preparation. So because of these, what the constitution ensures, The constitution ensures how long you can hold the office. Constitution ensures your salary. Constitution ensures that nobody can question your conduct. Constitution ensures that you cannot be removed easily. For the removal of you from your post, they need to get the 2/3 majority for your removal. So with respect to this, definitely you have the constitution has what constitution has justified your independence, how your independence can be justified there. But now the question may come, when the parliament brought up NJAC, did they in any way challenge these conditions in which the the independence of judiciary can be violated? No. But why did the collegium system oppose it? That is the biggest question. Why? What was the need of this opposition? Why did the collegium system oppose it? And also with respect to the collegium system, in favor of the collegium system, now if you are giving the arguments, the collegium system, with respect to the collegium system, we saw that on paper the recommendation of the collegium is binding on the president. But we had seen cases, for example, Delhi High Court advocate's case, where he was recommended by the collegium as the Delhi High Court judge, but the government did not appointed him. So the Supreme Court did nothing to that. And simply also the case with respect to the Gopal Subramaniam, he was appointed as the as the judge, but the government did not appointed him. So definitely, the collegium system in this regard, even though they have this, even though the consultation means concurrence, but still they cannot do anything with respect to that. Now we saw that how the constitution, how the constitution protects the independence of the judiciary, and in that we saw that how the judges can be removed. They can only be removed by the resolution passed by the both houses of the parliament. Now let's see how. Now let's have a look at how the Supreme Court or High Court judges can be removed in little detail. Let's see what does it say. What does the Constitution say? The Constitution says with respect to that it is the President who can remove them. President can remove them here. He will give the final order. But is it President would want any, tomorrow the President would want any judge to be removed? We have the Justice Yadav case going on, who is involved in the corruption. If President wants to remove him, can she proclaim that I had removed her from the office? No. There is certain procedures which are to be followed. What are the procedures? The resolution should be passed by both houses of the parliament. Passed by both houses of the parliament by this special majority 2. Special majority 2. On what grounds? What are the grounds for the removal that we need to know? Grounds are misbehavior, and the second ground is the incapacity. Misbehavior and incapacity. These are the grounds on which the Supreme Court or High Court judge can be removed. Misbehavior, maybe he was involved in the corruption charges. For example, right now there are allegations against the Justice Yadav. And incapacity, maybe he met an accident, now he is not in his mind. So we have sympathy for him, but we cannot have him in office. So because of these two conditions, on these two grounds, he can be removed. What is the procedure for removal? The Constitution is silent here, but it is the Judges Inquiry Act of 1968 which gives the procedure. Judges Inquiry Act of 1968 which gives us the procedure for the removal. So what is the procedure? First we have the Raj Sabha, we have Lok Sabha. In the Raj Sabha 50 members will start a resolution, and in Raj Sabha 100 members they will approach the chairman, in the Raj Sabha chairman and the Lok Sabha speaker about the file a motion, and it is up to the chairman or the speaker whether to accept it or not. It is his discretion with respect to the resolution. In the Raj Sabha it should be supported by 50 members. In the Lok Sabha this resolution should be supported by 100 members. Once it is accepted by Raj Sabha or the Lok Sabha, then once it is accepted, they will appoint a committee. Committee would be set up for that. And this committee will consist of the one judge of Supreme Court, one Chief Justice of the High Court, and one eminent person. This will consist of this committee, and they will investigate about this matter, whether this person for which the resolution has been introduced, whether he was guilty or not. Once they will pass the resolution, and once they will accept, once they will give their investigation and this person is found guilty, then this resolution is to be passed by both the houses by the special majority 2. Once passed by both the houses by special majority 2, in this time the 14 days time period would be given to the judge to to justify himself, whether he has done wrong or not. So once this would be done, it would be passed by both the houses, and then finally the president will give the removal order. So this is how he is removed. Usually, right now we had seen various cases with respect to various news articles with respect to Justice Yadav about his impeachment. So here you need to know that this impeachment process, it is only used for the president, not for the judges. For the judges, the term removal is used. So in this way, the judge is removed. Till now, how many judges have been removed by this process? The answer to this question is big no. Nobody has been removed till now. Let's see what will happen to the Justice Yadav. And one more thing you have to keep in mind, that this bill should be passed in the same session. It is not in the moon session you had introduced the bill and in the budget session you will pass it. No, it will not happen like that. In the same session in which you had introduced the bill, you had brought the resolution, in the same session this bill should be passed. So this is about how he is removed. Now let us see what are the jurisdictions of the Supreme Court. Let's see what is the jurisdiction of the Supreme Court. How does it deal with the federal matters? What does the Constitution say about that? Which, from now onwards, our discussion would be more specific to the prelims preparation. Let's have a look at, for this we have Article 130. Article 130. For example, Article 130, it deals with where does Supreme Court will sit. Where does Supreme Court will sit? It says, Article 130 says, it will sit in Delhi. Supreme Court will sit in Delhi. And can we shift the Supreme Court? Yes, we can shift the Supreme Court. It can be shifted to other places. Can be shifted to other places too. But for that, you need the approval. You need the approval of Chief Justice of India and the prior recommendation of the President. For that, the Chief Justice of India may, with the approval of the President, from time to time do so. Chief Justice of India, by the approval of President of India, from time to time can shift the sitting of the Supreme Court of India from one place to another place. So with respect to this, a question may come to your mind: why do we need to shift these benches? Why do we need to shift these benches? What is the reason for that? What is the rationale for that? If Supreme Court is only in the Delhi, which is rightly in the Delhi, and if we look at the geography of our country, Delhi is very far from the South Indian states. Delhi is very far from the eastern states. Delhi is very much near to certain states only, which are very much nearer to them. For example, the northern states. For example, UP and other states. So, how it is impacting? It is impacting the right of other people who are living in far-flung areas. It is impacting the right of those people to approach the Supreme Court. So, in this regard, the Supreme Court, the Chief Justice of India, from time to time can, by the approval of the President, can shift the sitting of the Supreme Court from Delhi to other places too, so that the justice would be served to everybody. But here there are recommendations with respect to that. Why do we need to shift the bench? Why do we need to shift the sitting of the Supreme Court? Why cannot we go for having the different benches of the Supreme Court? Why can't we have the different benches of the Supreme Court? For example, one bench would be in the north, one bench would be in the east, one bench would be in the west, one bench would be in the south, and one bench would be in the south. Why in the center? Why don't we go for this? So with respect to this, it was basically, it is very much recommended by the Law Commission also. It is accepted by the by the governments too. But here the Supreme Court has rejected it, And why Supreme Court rejected it and objected it? Because of two major reasons. What are two major reasons? First one, which the Supreme Court highlighted, the first reason, it will affect the status of Supreme Court as a national institute. The Supreme Court says, look at the Supreme Court, it is a national institute. It has its own status. Once it would be once there would be various benches of the Supreme Court, it is definitely going to impact the national status of the Supreme Court. What does the Supreme Court say? How they object it? First, it will affect the status of Supreme Court as a national institute. It will affect the status of Supreme Court as a national institute. And the second thing which they highlighted, regional benches can come under the influence of the local politics. Regional benches can come under the influence of local politics. So these are the two important points, objections which were laid down by the Supreme Court. But if we analyze these objections, what is the motive of the Supreme Court? The motive of the Supreme Court is that it should serve the nation. But once it is served, it is in Delhi only, and most of the cases, if we will do the research about it, if we will see what does the report say, most of the cases which are in the Supreme Court, they are from the nearby states, and least number of cases are from the southern states or the far-flung states. So definitely it is not serving the national interest. Second thing, it talked about the regional bench, that it may come under the influence of the regional benches. Then what about the high courts? Then they would also come under the influence of regional bench. Then why do we have high courts? And in the high courts we have this criteria. For example, in the Bilkis Bano case, when the case originated actually in the Gujarat, but it was shifted to the Maharashtra. And the reason for that was, it may come under the influence in Gujarat, it may come under the influence of the politics there. So because of that, it was shifted to the other state. Same can be done with respect to the regional benches also. So why these are the arguments which are against the objections made by the Supreme Court. These objections which are made by the Supreme Court, even though they may seem very much natural and accepted, but when we analyze them, there are various holes in those objections too. Then also, what is the recommendation? What are the further recommendations with respect to the regional bench? There is a lawyer, there is a ex-CJI, not a lawyer basically, he is an ex-CJI, KG Balakrishnan. He has given his opinion with respect to this, with respect to the regional bench of the Supreme Court, and his opinion is widely respected by many. What was his opinion? He opined that there should be two benches of the Supreme Court. We should split the Supreme Court into the Constitutional Court and the Cassation Court. We should split the Supreme Court into the Constitutional Court and split the Supreme Court into the Constitutional Court and the Cassation Court. In the Constitutional Court, only the federal matters will come into the picture, and in the Cassation Court, only the other matters except the constitution, except the federal matters or the constitutional matters will come into the picture, so that it can reach to the every corner of the country. This was the recommendation made by the KG Balakrishnan. So here I would like to mention one thing, that one of the major difference between our judiciary and the US's judiciary is that in our judiciary, at the top we have Supreme Court, then we have the high courts. But in the US judiciary, at the top there is federal courts, then they have, for every state they have the Supreme Court. In our judiciary, the case will end at the Supreme Court at the top. In the USA, the cases will end at the Supreme Court. But what for there is the federal court? This federal court will only deal with the federal matters. So this federal court will only deal with the federal matter. This is the difference between the US's judiciary and the India's judiciary. In India, all the cases would be heard by the Supreme Court, but in the US, only in the federal courts, only the federal matters would be heard. So this is the why I remember it, because of the KG Balakrishnan recommendation, what he suggested, that we should split the Supreme Court into two, the Constitutional Court and the Cassation Court, where the Cassation Court will act as a court of appeal, and the Constitutional Court, it will deal with the constitutional cases, which are getting delayed, it will be the federal structure, it will be in federal nature. So with respect to this, there are various arguments in favor that it will increase the accessibility and convenience of the people, it will connect more people to the courts, and also it will lead to the speedier justice. But at the same time, there are some arguments which are against it. One of the argument is uniformity and consistency will not be followed if the Supreme Court will be split, or there would be various regional benches. We have the burden of judicial bureaucracy, it will also increase, and also it in a way leads to various verdicts. For example, if we have various regional courts, they will give different verdicts, and finally we know that the Supreme Court is the highest place which solves the verdicts. If there are verdicts given by different zones, different regional benches, different verdicts, then definitely it will lead to the further misunderstandings, it will lead to the further it will further disintegrate the unity in this state. So it is better, according to the Supreme Court, to have the Supreme Court, and to have it in one, to have its sting in Delhi, and whenever it is necessary we can shift it, as we saw in under Article 131. So with this, let's see what are the various powers of the Supreme Court. First, we will see what is the jurisdiction of the Supreme Court. With respect to this, let us try to understand the jurisdiction of the Supreme Court. Jurisdiction of Supreme Court. Let's try to analyze it. With respect to jurisdiction of the Supreme Court, there are two types you would have heard of original jurisdiction and the exclusive jurisdiction. What is exclusive jurisdiction? This case will not be handled by any other case, which no other court can handle. For example, there are federal cases, they can only go to the Supreme Court. For example, there are disputes between the center and the state. Federal cases, it will only go to the Supreme Court. There are cases with cases related to the election disputes of the president and vice president. These cases will directly go to the Supreme Court. It has exclusive jurisdiction related to these cases. These cases cannot be handled by any other cases. What is the original jurisdiction? The original jurisdiction is you can directly file your case into the Supreme Court. What is that? For example, fundamental rights. If your fundamental right is violated, you will directly go to the Supreme Court. But you can also go to the High Court. So this is the difference. About the exclusive jurisdiction, this case will not be heard by any other court. About the original jurisdiction, you can directly approach the Supreme Court, but this case can be heard by the lower courts too. That is the difference between the original and the exclusive jurisdiction. And what are the exceptions with respect to the jurisdiction of the Supreme Court? The exception is, for example, there is pre-constitutional treaty. For that, this case cannot directly go to the Supreme Court. It can review it, as the judicial review is the basic structure of the Constitution. But the pre-constitutional treaty, if there is case related that cannot go to the Supreme Court directly. Then we have the various agreements with foreign countries. It cannot go to the various agreements, they cannot go to the Supreme Court. Then we have interstate river water disputes, which we had discussed in the center-state relations. Interstate river water disputes, they cannot go to the Supreme Court. The Supreme Court does not have jurisdiction over it, but still Supreme Court can review them. It is not beyond review jurisdiction of the Supreme Court. So this is about the jurisdiction of the Supreme Court. What is the original jurisdiction, what is the exclusive jurisdiction, and what are the exceptions to the jurisdiction of the Supreme Court. Now let us see its further jurisdiction, or further powers of the judiciary, of this further powers of the Supreme Court. Let's have a look at it. We discussed it about under Article 32, the writ jurisdiction. We had discussed that, no need to repeat it here. The Supreme Court has the writ jurisdiction. Then the Supreme Court had the advisory jurisdiction under Article 143. Article 143, for example, SC acts as an advisor of the President of India. Supreme Court under Article 143 acts as the advisor of President. So this advice, president, can refer any matter to the Supreme Court and ask his advice. So about this matter, any matter, it can be of two types. Any matter, one is pre-constitutional, and second is post-constitutional. If the matter is related to pre-constitutional, then the Supreme Court has to give his advice, has to give their advice. And with respect to the post-constitutional, Supreme Court may give and may not give the advice. So this you have to remember. It acts as a advisory. It has the advisory jurisdiction. Then, is this advice binding on the president? The answer to it is on the paper, no. This advisory jurisdiction, it is not binding on the president. On paper, at least say no. If the question comes, the advisory jurisdiction of the Supreme Court under Article 143 is binding on the president, then the answer to it is big no. Please remember that. Then after that, the Supreme Court has the appellate jurisdiction. It has the appellate jurisdiction. What is this appellate jurisdiction? For example, there are various cases which originated in the lower cases. For example, they are related to the constitutional cases, they are related to the criminal cases, they are related to the civil cases. This Supreme Court has the appellate jurisdiction. It can revisit those cases. If appeal is filed in the Supreme Court, then Supreme Court has to accept it. But how this appeal will be filed? For that, the person who is involved in it, he will have to get the certificate from the High Court. The person will get the certificate from the High Court, and then he can appeal in the Supreme Court. With respect to the constitutional, if the case is related to constitution, if the case is related to criminal justice, if the case is related to the civil justice. But with respect to the criminal justice, if the punishment is death penalty or life imprisonment, for that you don't need the certificate of the High Court. Rather, for the rest of the cases, you need the certificate of the High Court. Now the question may come to your mind, what if High Court refuses to give the certificate? What will happen to them? For that, we have Article 136. Let me drop it first. We are discussing the appellate jurisdiction of Supreme Court. It has jurisdiction in the constitutional matters, in the civil matters, in the criminal matters. For example, in the constitutional matters, if any case will reach to the Supreme Court has to accept it. But for that, they need the certificate of the High Court. For the criminal matters, Supreme Court has to accept it. For that, they need the certificate of the High Court. And for the same with the civil matters. But in the criminal matters, if the punishment is life imprisonment or the death penalty, then the Supreme Court will have to accept it without the certificate of the High Court. Now the question may come to your mind, what if this High Court refuses to give this certificate? For that, we have Article 136. What does Article 136 says? Article 136 says, what if High Court does not issue certificate? It says Supreme Court can be approached by the petitioner using the special leave petition. The Supreme Court will be approached by using the special leave petition. This special leave petition, it is the discretion of the judge. He may accept it, he may not accept it. The Supreme Court judge may accept the special leave petition, he may reject it. It is up to his discretion. This special leave petition, it can't be claimed as a matter of right. This you have to remember. If the Supreme Court does not accept the special leave petition, you cannot go to the court again and ask it as a matter of right. It can't be claimed as a matter of right. You have to remember it. Can't be invoked in case of Armed Forces Tribunal. For example, if Armed Forces Tribunal has given any case, then the special has given any verdict, then the special leave petition cannot be invoked in such matters. So here two things you have to remember with respect to the special leave petition. First, remember it is Article 136 which deals with it. Second, it is the discretion of the judge whether to accept it or not. You cannot claim it as an right. Third, if it is against the army, if it is against the Armed Forces Tribunal, then it can't be encouraged. It cannot be invoked. So these are some important aspects related to special leave petition. So with this, I hope you had understood the appellate jurisdiction of the Supreme Court. Now there is third jurisdiction, which is the revisory jurisdiction of the Supreme Court. revisory jurisdiction of Supreme Court. So what is this revisory jurisdiction of the Supreme Court? For example, if the Supreme Court will give any judgment and this judgment is binding throughout the territory of India, but it is not binding on the Supreme Court, that you have to understand. Now, under this revisory Supreme Court, we have one important term you would have heard about, the review petition. For example, there is a case in the Supreme Court. We had the Supriya versus Union of India case, where the homosexuality was not, two homosexuals cannot marry. It was established that the right to marry is not for them. So they wanted to review it. So they want to review it. For that, they can use the review petition. They want Supreme Court to review it. So for that, they will use the review petition. But with respect to the review petition, there are some conditions which are to be followed. What are those conditions? First, it should be filed within 30 days. Within 30 days, you should approach the High Court. You should approach the Supreme Court. And how you can go for the review petition? Certain conditions should be fulfilled. First one, the error, there is error in the previous judgment. Second, new fact has emerged. If the new fact has emerged, then you can ask for the review petition. And then the third, the mistake in the judgment, if there is mistake in the earlier judgment. If these three factors had emerged, if there is error in the previous judgment or the new fact has emerged or mistake in the earlier judgment, then within 30 days you can go for the review petition. And this review petition, it would be heard by the same judges who gave the original verdict. It will be heard by the same judges. And once, for example, let's suppose the judges, they reject the review petition. What is the option available to the petitioner? Now the option which is available to the petitioner is the curative petition. Under this curative petition, this should be filed within reasonable time of the dismissal of the review petition. Once the review petition is dismissed, it should be filed within the reasonable time. It should be very reasonable time. Second, this case will also be heard by the same judges plus 3 senior judges. It would be heard by the same judges plus 3 senior judges. And it is mostly about to happen that this curative petition may also get rejected, because it is heard by the same judges once, plus 3 more judges. For example, it was heard earlier, this was heard by the 5 judges. Now 3 more judges will hear the curative petition. Mostly by the majority it may get rejected. And after that, after the curative petition, we have an important article, which is Article 142. Suppose if this curative petition is also rejected, or in any case, the Supreme Court can invoke Article 142, and under Article 142, they can render complete justice to anyone. This is the extraordinary power which the Supreme Court has. So with this, I hope you had understood the basic important points related to the Supreme Court and also related to the High Court. Where it was necessary, I had elaborated over them. So tomorrow we are going to discuss the judicial activism and various other aspects related to judiciary. Some extra constitutional organs of the judiciary, we will try to discuss that. With this, we will complete today's discussion. I hope you had understood it. If there is any doubt, please do write in the comments. We are here to help you. Thank you for staying with me. Thank you very much and have a nice day.